Okay, good morning. This is now chapter 9 lecture. We have looked now at both the law that the police have to follow on the street. We've also now in 8 looked at um, accountability, the kinds of things that the police are not allowed to do. And now we're moving on to sort of the consequences section, which is going to be civil and criminal liability. What is the civil and criminal liability for police misconduct? I, I would, I hope that by now you see a couple of things. One is that being a police officer is not easy. The rules that they have to apply are not super simple. There's a lot of variability or interpretation that's left to the police officer on the road to decide what is the right thing to do. And also that we as a society have a tendency to what we call armchair quarterbacking, right? Which is we sit and look at it after the fact and criticize actions that don't take into account uh, the emotions and all of the circumstances that the officer faced at the time that they made the decision that they made. So let's move on with that. I'm going to share screen and we're going to do the slides as we go along. Let's do this. Yep. Right. So chapter 9, civil liability, failing the public trust. Um, the improper or sometimes even illegal actions of the police are uh, incredibly costly, incredibly costly. It's also not entirely clear what the actual incidence of police misconduct is, right? So you can imagine all those reasons why you are nervous when you see the police officer behind you, even though when you know you haven't done anything wrong. The number of interactions that occur with the police where the person who is the subject of that interaction doesn't do anything about whatever improper behavior that was attributed to the police. Um, that being said, the police face over 30,000 civil actions annually. And that compared to all of the police citizen encounters that occur annually is actually quite small. There's literally hundreds and hundreds of thousands of police citizen encounters every single year. Um, so one of the questions that we always sort of ask our students is to think about, and this is about anything that you see that occurs in the media. Think about um, what we call the base rate. The base rate is that yes, this is a horrible thing, and we should do something to keep it from happening. The second question is how how often does it actually happen? I actually have to pause just for a second. Right. So we're talking about base rates and how often these things actually happen. At the same time, I think earlier in one of the lectures, I said something along the lines is that we have a tendency to look at police behavior in the same way that we look at like brain surgeons, right? We hold brain surgeons to an extremely high standard, and really one mistake is one too many. And we kind of look at police behavior the same way. And so then one of the questions, and it, it may end up being a prompt that I have you do, but one of the questions you should be thinking about in the back of your mind is well, what's the acceptable rate of mistakes on the part of the police, right? Um, Is it okay if the mistake didn't actually physically harm someone? Does that make that mistake okay? Um, or are all those mistakes actionable? Should they all result in some sort of a discipline of the police? And then the other question then that you're going to also need to ask is that even this number, compared to all the hundreds of thousands of interactions with the police, um, what's the what's our reaction? How do we change the police to make these things not happen again? Right? The cost of civil suits, as I indicated, are high. There's judgments and settlements, costs of defending departments in court, cost of liability insurance. We'll talk a little bit about liability insurance in a little bit. And then also the effect it has on police morale. When police officers are walking around thinking that they are like every single step they take is going to be under scrutiny, and that there is no room for mistakes. You can imagine why some police officers are walking around in a fairly bad mood, right? Um, so let's move on. In the same way that there are costs of those lawsuits, there's also benefits of those lawsuits, right? It keeps the police accountable, or certainly moves them in the direction of being accountable, right? It does give meaning to citizens' rights, right? This is the whole sort of tension about when we're talking about the Fourth Amendment rights, protection of the individual from the state. You know, we can talk about having those rights, but if those rights aren't, if we don't do these things like the lawsuits and the accountability measures that we use, then maybe there's an argument that those citizens' rights don't have any meaning, right? The number three, the fostering better police training. And, you know, for me, that's sort of the game, right? Is that, you know, if you accept that we need some form of police, and maybe you don't, but if you accept that we need some form of police, then what does that police agency look like? What training would we do to reduce that 30,000 suits down to, you know, none, or, you know, something smaller, some more reasonable number that we all feel like we could live with? Um, so you've got the improving of the actual police officers training, but then you also have the correcting the deficiencies of the reviews. How is police behavior reviewed? Oftentimes, police behavior is reviewed by the police, and whether or not that's a good model, and whether or not we should maybe consider other ways of reviewing policies, practices, and customs. And then there's another aspect of this, which is that there are lots of frivolous lawsuits. I mean, you think about it, um, especially considering that there are localities or municipalities that are willing to settle a lawsuit rather than expend the resources to fight it. There are a lot of lawsuits that are filed that are probably not worthwhile. They're not really alleging police misconduct. Um, and sometimes those lawsuits get settled anyway. It's a nuisance suit. The police want to make it go away. They'll offer a number to make it go away. And no matter how frivolous it is, it would count in that 30,000 lawsuits where there was a payout, right? Um, but also keep in mind that the police perception of what is frivolous and the legal definition of what is frivolous sometimes and often don't match. So we'll talk a little bit about that. I will say that frivolous lawsuits against the police are fairly rare. And the reason why is because, and we'll talk a little bit about this, is that the rules governing those lawsuits are sort of police beneficial. So a lot of those truly frivolous lawsuits, if they actually get filed, get kicked out fairly early by the courts. Now, let's talk a little bit about basic terms and concepts. Laws are enacted in three different ways: legislation, administrative regulations, regulations that are created to guide agency behavior, and but sometimes regulations that don't necessarily have a built-in sanction for violation of those regulations. And then court decisions, where the courts say, regardless of what the law, what the statutes say, or what the regulations say, common sense, um, basic human rights, constitutional rights, um, sort of mandate that uh, that a plaintiff wins. There is the concept of stare decisis, right? Let the decision stand. So if there's an old case that talks about police liability, the courts are sort of reluctant to overturn those kinds of um, those cases. And the flip side is even more true. If there's old case law that suggests that there is no liability on the part of the police, it's very, very hard to get modern courts to change that. So judges rely on that precedent when there's no solution in the existing body of law. When we're talking about lawsuits against the police officers, we're almost always talking about torts. Torts is where one human being does a wrong against another human being, the second human being, and then that gives that aggrieved human being a right of action in court, and you're suing for money, right? It's not suing to put someone in jail. That's a different thing. That's the criminal side. We're talking about saying the police did something wrong, and as a result of that, I was damaged, and I'm entitled to some sort of monetary award to make me whole. So tort is an injury inflicted on one person by another. Negligence is really what we're talking about in tort, is that the police officer has a duty of how they behave towards human beings. If they violate that, if they breach that duty, and their breach, what the police officer did is actually the cause of the damage to the plaintiff, which is something we'll talk about causation as we go along. And then there's their damage. Is there actual damage that can be awarded? There's simple negligence, where it's just a reasonable act performed without due care in the scope of employment, and then gross negligence, where everyone would agree that it was something that the police should not have done. And then you get into willful or malicious acts. When you get into willful or malicious acts, those are more likely going to do two things. They're going to create a criminal liability on the part of the police officer and also create civil liability on the police officer and perhaps the police officer's employers. Intentional torts, officer engages in a voluntary, in other words, the officer engages in an intentional act that has a substantial likelihood that act will result in injury to another. In other words, the officer knows he's doing something wrong, and that wrong, the officer knows it will harm someone, or should know that it would harm someone. And then we have this unusual kind of tort that really only applies to the police officers, which is a constitutional tort, where the officer has a duty to recognize that person has a constitutional right. And because they have the constitutional right, the officer has an obligation to protect that right. And if they don't, then the police could be liable for a violation of someone's constitutional. As I indicated before, an act could be both a crime and a tort. Civil and criminal courts have different standards of proof. In the criminal arena, you have to prove crimes beyond a reasonable doubt, and in the civil arena, you have to prove it by a preponderance of the evidence, which is that 50% plus one that sometimes people confuse with probable cause. In the civil arena, to obtain a judgment, you have to prove it by a preponderance of the evidence, which is that 50% plus one. It's just more likely than not. And then most tort suits are filed in state courts. A couple different reasons. Federal torts are harder to prove. They are more expensive to pursue. The filing in state court is much less expensive. Now, that being said, there are ways that federal court can acquire jurisdiction of police misconduct. There are what are called 1983 suits, and they were 1983. I think it's a little further on, but I'm just going to say it real quickly. 1983 suits came about when the Ku Klux Klan was active, and it the actions of the Ku Klux Klan were sanctioned or approved of by the local government or the state government. And then we have what are called Bivens torts. Bivens versus 6 unknown named agents of the Federal Bureau of Narcotics. This is where police officers execute a search warrant. They do a lot of bad things, and they're bad enough that they are a violation of not only state law but also federal law, which then allowed a separate misconduct suit in federal court. There is what's called a respondeat superior doctrine. The idea is that even if the agency, the police agency or the supervisor doesn't know of the actual actions of the police, if the police are acting under the color of the agency, they're doing it, they're on duty. The idea is that not only can you hold the police officer responsible, but you may also be able to hold the supervisor responsible, the agency responsible, and even the state that establishes the agency responsible. It's another fancy term called vicarious liability, but the idea is that you could actually, depending on the circumstances, hold all of those entities responsible for the actions of the police officer. As you can imagine, is that unless it's fairly clear that the agency or the supervisor knew or should have known what the police officer was up to, courts have a reluctance to extend a liability to the supervisors and administrators. So in the same way that we have respondeat superior, where you can hold the supervisors responsible, we also have sovereign immunity doctrine, which means is that you can't sue states, state agencies, instrumentalities of federal courts at all. You can't. You can sue municipal governments, which is city governments, smaller governmental entities within the state, but you can't sue the state directly unless the state establishes that there are certain kinds of suits that you can bring against the state. They can actually consent to allowing you to sue the state. And in many, many states, the states have agreed that police misconduct suits they would accept or allow people to sue the state for actions of law enforcement agencies. So as we talked about, 1983, originally enacted as a Civil Rights Act of 1871, provided an avenue for federal courts for relief of alleged civil rights violations. So the idea was, as you can imagine, if it's a state that's sympathetic to the Ku Klux Klan operations, and for those of you who maybe don't know what the Ku Klux Klan was, it was I'm not sure how to describe it. It was really kind of a group of racists who wanted to really just sort of assert white supremacy, which would be against anyone who wasn't white, not just African American folks or other kinds of people. It was every person of color, folks from a Jewish background, anybody who was not what they call the Aryan race, trace themselves to white, European ancestry. And in the late 1800s, early 1900s, really all the way up into the civil rights era of the 60s, the Ku Klux Klan was in operation and causing all kinds of problems. And oftentimes in certain states, the state was not either looking the other way, knew what they were doing, and didn't do anything to stop it, or sanctioned it, said it was okay, and participated in aiding the Ku Klux Klan all the way up until the Civil Rights Act of 1871. And it said you could now, because obviously if the state thinks the Ku Klux Klan is okay, well then trying to sue within the state was going to be useless. So the idea was that it was going to give someone a right of action in federal court for the actions of the Ku Klux Klan that were being sanctioned by state agencies in the individual states. The law did not originally include police misconduct. So when we talk about stare decisis, you got to always think about it like this: like, what were the original laws that govern this conduct or this behavior, and how have they changed over time? This is an example where when it was really talking about, this sort of private group that was being supported or approved of by state agencies, but was not a state agency. So the question was whether, at what point does it include police misconduct litigation? And you can probably imagine why eventually it got extended to police misconduct, because in a lot of those situations, police officers off duty were participating in the Ku Klux Klan. So there was a connection, or at least a perceived connection, between police misconduct and the activities of the Ku Klux Klan. So in Monroe v. Pape, extended the 1983 actions to individual officers and their actions. But there are other examples where they've dismissed the city of Chicago from suit as not a party to the individual's actions. So it originally said in 1983's you could sue individuals, and then they extended it that where you could actually sue the agency itself. So more Section 8 in 1983 lawsuits. Lawyers believe clients get more competent judges, juries in federal court. So this is the reasons why you want to go to federal court. Is that the judges are they're apart from what goes on in a particular state, so they're less likely to have an opinion about it. They're less likely to feel any pressure from people in the community who necessarily wouldn't be sympathetic to the lawsuit. The jurors would be federal jurors, probably in locations that don't come from the actual state or locality where the alleged misconduct occurred. So you're more likely to get an objective judge or jury. Federal prosecutors had at least when they first started, had a tendency to be more aggressive, arguing to jurors from multi-county area, right? Because if you're arguing to a jury that comes from the exact same location where these misconduct occurred, you have a tendency to find jurors who might be sympathetic with some of that conduct. But if you argue to a broader set of the community, that's a cross section of a larger set of the population within a state, then what you have, you're more likely to get objective jurors. And then finally, federal rules of pleading and evidence are uniform. Federal procedures of discovery are more liberal. In other words, you can get more information about what about the case before you go to court. And the published case law helps lawsuit preparation. So there were really lots of advantages for suing someone in federal court rather than state court. As I indicated, that in 1978, they applied the 1983 actions to local governments. States, on the other hand, so local governments you can sue, states grant absolute immunity. So like I said, unless the state agrees or consents to being sued, then you can't sue states directly. And then judges, prosecutors, legislators, federal officials have absolute immunity also. Now, what kind of actions led to 1983 lawsuits or liability? Obvious ones are unconstitutional use of force by the police, um, police brutality, again, unlawful use of force, misconduct during off-duty activities under the color of law. And we'll talk a little bit about that, but the idea is that someone who's an off-duty police officer who then uses his gun and his badge to act, even though he's not actually working. Wrongful death situations where use of force results in the death of someone and the use of force is found to be not reasonable. False arrests, searches and seizures that were illegal or improper, and then that sort of broader, more vague concept of negligence by the police. Just a reminder, the 1983 suit is a civil statute, so we're really just talking about money. We're not talking about whether or not the police officer gets prosecuted and goes to jail. That's a separate situation, and that's under Section 242, which is the criminal law, criminal offense for anyone acting willfully under color of law to deprive any person of the rights and privileges. So that's the idea is that for you to get criminal liability for a police officer, you have to show that the officer acted intentionally or willfully and acted specifically to deprive someone of a constitutional right. Applies to the police and other public officials, applies to protected groups, race, creed, religion, sex, and case law over time has broadened those protections, as you can probably imagine. The issue of liability of police supervisors. It's this concept of negligent supervision or negligent retention. It's a breach of the duty to provide effective systems for evaluation, control, monitoring of employee performance. So this is like, for those of you who, if you've worked in government at all, any kinds of problems that occur in the workplace, they're oftentimes documented and kept in a file. And also your supervisors, agency heads will document like what they did to address the problem. Because at some point, if the employee who misbehaves or does something that they weren't supposed to do, if that continues, then the supervisor's got to do something about it. And if they don't do something about it, it could rise to the level of what we call negligent supervision or negligent retention, where they kept the employee on even though that there was a problem with the employee. And you see it a lot in the police situation where you have a problem police officer where there had been documented issues of use of force. And because all the police officers know each other, the police have a tendency to be slow in addressing the problems that police officer has, and also slow in firing them when they continue to do bad things. And then when they do a really, really bad thing that results in the police officer getting sued, it can very easily include the supervisor being sued because the supervisor knew or should have known that the police officer had problems and that the supervisor didn't do anything about it. Supervisors may be liable for injuries resulting from official police actions or custom. May be sued for improper hiring, improper training, improper supervision of officers, and then also can be sued by officers who believe they were improperly disciplined or terminated. So there's that other side of it, right? You could see the risk-averse agency that says we're firing you for the first issue that we see, and then the police officer sued them that says we were improperly disciplined or terminated. We weren't given enough chances to do the right thing. And a big source of lawsuits against police officers is the use of force continuum. So we're talking about everything from the use of a firearm to the use of tasers or electric stimulation devices, to batons, flashlights, asps, to hand control, which would include chokeholds, and then below that is training officers to de-escalate, be able to use words to get people to comply. So many police tools can result in injury or death if used improperly. That's one of the big issues with the tasers or the electronic stimulation things. They're not supposed to be used on certain parts of the body. They're not supposed to be used in certain kinds of weather. And they're not supposed to be used on certain kinds of people who are sensitive, right? So older folks who are relatively feeble, you use those electronic devices on someone like that. Not only will they, you know, comply, but you might end up killing them because it's not really the appropriate person that you would use that kind of device on. Uh, because of that, there are agencies who are either more or less risk averse about the use of those different levels of devices, the use of a car in chases, the use of the car to do what we call pit maneuvers, that where they use the car to make the car that you're pursuing essentially crash or come to a stop. Um, so it raises all kinds of issues on the electronic control devices, safety of the devices, excessive use of the devices. Officers are trained to use those devices in fairly narrow range of circumstances, and the question is whether or not the police officer went outside of that range, whether the police officers had sufficient training or at least the training that they were required to have, right? What is the policy, and is it a clear policy that gives officers sufficient guidance as to when they use these different things, and then the circumstances of the specific application of it. There is this concept called duty of care. So it's a little bit tricky. I'm want to diverge a little bit. We have a Good Samaritan doctrine. It does not exist in Virginia, but Good Samaritan doctrine does exist in other states. The idea is that if someone gets into a car accident and you pull over to render aid, you are held to a simple negligence standard, which means is that you won't be held liable unless you're grossly negligent, because you have stepped in to try to aid. We want to encourage people to aid folks, so we don't want to hold people liable for simple negligence in trying to help someone, right? So you try to help get someone out of the vehicle, and it turns out that moving them actually aggravates the injury that they have. Unless you were acting grossly negligent, you're not going to be held liable. So there's always this kind of concept of a duty of care doctrine. The police, and this is important, it's something that you need to really think hard about. The police have no duty to protect the general public from harm, absent a special relationship. We'll talk about what those special relationships is, but it's that first part is that although the police exist, they are our police agencies in the United States are reactive. They're not proactive. So they won't go out looking for someone and say, you look like you're a criminal, I'm going to take you into custody, right? You can imagine what our country would look like if we had that kind of system where the police could just go lay hands on people and say, you look like you might be a danger, so I'm going to grab you. No. So the police are not held liable for not catching someone who robbed a bank, right? But if the police embark on that and react to that, and lay hands on someone that they believe is the robber, well, then now maybe there's a duty of care that kicks in. But there is no general duty. You can't sue the police for not anticipating that a robbery was going to occur at the Safeway. And we'll talk a little bit about what the special relationships are a little bit later. Police legal duties arise from a number of sources. Sometimes the law, just the statutes, impose upon the police a duty, and then if they breach that duty, that could create liability. There are customs, court decisions, and then agency policies. Special relationships. Those special relationships where the police officer knows the likelihood of harm to someone if they fail to do their duty. In other words, if a police officer takes someone into custody, they now have a duty to make sure that they don't harm the person while they're being processed in after being charged, right? So the police officer has to make sure that the inside of the vehicle is safe. The police officer can't, when they know someone that is in distress, they can't uh, and the best example is if I'm a police officer, I respond to someone on a wellness check and I knock on the door and the person is not in good shape. And rather than calling an ambulance to have them picked up, you just say, stay here, and they close the door and lock it and walk away. And then say, yeah, we'll get it at the end of the shift. We'll have someone go check on them, and that person dies in that interim. The police officers are now know or should have known that there was a person that was in need was of help. They were in the position to help the person and just chose not to. That creates that special relationship that doesn't allow them to just shirk that responsibility and walk away. It's defined by circumstances surrounding injury or damage, role as a community caretaker. If the police roll up on someone in a traffic accident and someone is injured, the police can't just walk away. They've got to now do something to get people aid. And if they do walk away, then they've acquired that relationship and they breached the duty in that situation, and they're going to be liable. The special relationships can be based on 3 different criteria: whether the police officer could have foreseen that he or she was expected to take action. So in that situation where they go do a wellness check and someone's not well, all right, so you kind of know that you got to do something. That person needs help, right? Same thing with the auto accident is when you pull up on an auto accident to provide aid, and then you don't provide the aid, right? Departmental policies or guidelines that prohibit a certain course of action, right? And then spatial temporal proximity of officer's behavior to injury damage. Officer knows that someone is injured. They can't just walk away from it. They acquire an obligation, what they call a community caretaker obligation, where they need to render aid. Now, one of the biggest issues that we see in courts is this idea of proximate cause. You could have a situation where the police officer had a duty and they in fact breached the duty. They did not do what they were supposed to do, but they were actually not the cause of the damage that the person who's suing actually received. And the example I can think of is where the police officer tries to initiate a traffic stop on a motorcycle. The motorcyclist doesn't stop. It becomes a pursuit. Now, there may be a policy in the police department that says if it's just a traffic offense, you can't exceed the 20 miles over the speed limit. And if it does, then you have to break off the chase. In this situation, the police officer has exceeded the 20 miles over the speed limit, but then the motorcycle, thinking that they've gotten away, pops a wheelie. And as they're popping a wheelie to show off that they've gotten away from the police, they wreck the motorcycle, and their damage is substantial. It's not the police officer's breach that caused the type of damage that the plaintiff received. The plaintiff would have gotten away if they just kept 2 wheels on the road. They chose to pop a wheelie, and it was the popping the wheelie that caused their damage. It wasn't the running from the police that caused the damage. And therefore, the police officer's behavior was not what we call the proximate cause. It was not it's what we call but for. But for the police behavior, would this injury have occurred? And it wasn't the police behavior that caused the wreck. It was the popping the wheelie that caused the wreck. And therefore, the police behavior wasn't the proximate cause. That's the argument. And as I indicated, proximate cause is established by asking, would the plaintiff have sustained the injury or damage but for the officer's conduct? And the requirement of negligence limits liabilities in situations where damage would have occurred regardless of the officer behavior, like I described. So of examples of duty of care situations, police persons in custody. Once someone is taken into custody and taken to the jail, both the police and the jail personnel have responsibilities towards the people they're holding. Like police have a duty of care to persons in custody, right? So you can't leave them in a cell without food and water and clothing. If you know that they are in physical distress, you have to do something to obtain aid. Police have to take reasonable precautions to ensure health and safety of detainees. And that duty can extend to persons in custody outside of jails. Like I said, in the back seat of the police car as they're going to the jail, or if they're transporting the person from one jail to another, or they're transporting someone from a jail to a hospital. The police officers have to they now have a duty of care to take care of that person while they're in their custody. It does not uh, result in liability for people who do self-inflicted injury, or they harm themselves or they commit suicide, unless the police have some reason to believe that the person is suicidal. That we talked about people being on suicide watch, and because they're on suicide watch, police officers, jails take special precautions to prevent um, inmates from doing self-inflicted injury. As we indicated about safe facilities, they must provide the safe facilities, vehicles, and temporary custody. Facility design may be a source of negligence. So sometimes you'll have these jails where the doors don't have windows that are big enough so you can see what's going on inside the room. And someone's inside the room and they're in physical distress, and the police can't see it because the design of the door is set where they wouldn't be able to see it. There's an argument that would be actionable. That would be the family of the person who harms themselves could sue because of the design of the facility. There's also failure to protect when there's orders of protection. You know that there is a protective order against a defendant, and you get called out to the house. The defendant is at a place that they're not supposed to be. And you just tell them to settle down for the night, and then you walk away as a police officer, but you don't enforce the protective order. A protective order would require you to remove the person who is the respondent of the protective order, and you don't do that. And if you don't do that and harm occurs, then you're gonna be on the hook for not enforcing orders of protection. And as you can imagine, that occurs most often in these battered women's cases or domestic violence cases. But where you also see it is when police officers are using an informant, and then they inadvertently release really two kinds of information. One, that that person is in fact an informant, and then two, how you find that person, their address, their contact information. And if that person gets identified as an informant and then they get harmed because people know that they're an informant, and police could be liable for negligently identifying and releasing that information. Now, police have no special privileges or immunities in routine operation of a patrol vehicle, right? So, we always sort of suspect that sometimes police officers are using their emergency equipment, but they're not actually going to an emergency. That's what we're really talking about. Police officers are supposed to obey all of the traffic laws unless they're responding to an emergency. And so if they were found to be sort of violating the rules of the road and they weren't actually investigating or responding to an emergency, then they would be liable in the same way that anyone else would be liable. On the other hand, police responding to emergency situations are governed by statutes covering emergency vehicles. We have statutes that cover emergency vehicles, what they can and they can't do, and what kind of lights they have to have on if they're going to violate the traffic rules to respond to emergencies. Police pursuits in some states, the police pursuits, you're allowed to, if you've broken the law, the police can pursue you at any speed, but it also has a high potential for injury, property damage, liability. Most agencies now balance the type of offense with with safety, right? So if the police officer is chasing after someone for a bad tag on their vehicle, what's the limit on what the police can do? Can the police use what we call the pit maneuver, where they use the car to hit the car that they're chasing to make it pull over. Can they do a 95, 150 mile an hour chase to stop someone with a bad tag? Most agencies now have rules that says that it has to be the offense has to be of a certain severity to justify high speed chases. And this sort of rule at the bottom: pursuit justified only when need to apprehend suspect outweighs the degree of danger created by the pursuit. And just a reminder, you have the slide deck as an attachment below where you will view this video. So if for some reason you can't see the slide deck while I'm lecturing, you can open up the slide deck while you're watching the video and scroll down the slides as I'm speaking, because I'm following the slides pretty closely. Computer evidence has been a source of liability, and that's relatively recently. Increased exposure to computer evidence has increased potential legal liabilities. Police officers seize a computer for a specific purpose, and while they are analyzing the computer, they accidentally destroy business records. And those business records were essential to the running of a particular business that is not liable for any kind of criminal liability. That sort of inadvertent or negligent loss of the data can subject the police to liability. More trickier things, computer information that contains information about individuals, individual information of people, financial information for people. If it's not directly related to what the officers are investigating and they somehow release that or destroy that information, that could generate liability. In the same way, the body camera and that body camera footage that's on the police officer gets loaded into a computer. The police now have an obligation that they didn't used to have, which says is that if they're going to use that body camera footage, they have to be sensitive to whether or not it's also releasing information or images of otherwise innocent people. Now, we've talked about all the things that allow the police officers to be liable, but now you lay on top of it is that police officers historically have enjoyed what we call qualified immunity. Most government entities enjoy some form of qualified immunity, and the idea behind it is in the same way that we have immunity for Good Samaritans who are willing to help people that they're not required to help. And as a result of that, we only require liability if they act grossly negligent rather than simple negligence. It's sort of the same kind of rule. The idea is that the Supreme Court wants to give police some breathing room if they make reasonable but mistaken judgments. And the situation goes something like this. Police officer acts, they do something. It turns out that what they did was wrong. The question then, that's the first question. Did they do something that we can all agree was wrong? They weren't supposed to do it. And then the second question was that wrong the kind of wrong that police officers knew or should have known was wrong, and therefore that they shouldn't have done it? And a lot of situations, what we're talking about is where like a police officer arrests on a warrant, but that warrant has been withdrawn, right? And so the police officer makes the arrest even though the warrant has been withdrawn. It's an illegal arrest. We can all agree it's an illegal arrest, but then the question is how the officer knew that this warrant was a good warrant. Did the officer know, or should the officer have known that that warrant was not a good warrant? And that's why sometimes you'll see police officers, they'll call in to confirm a warrant Even if they think the warrant exists, they'll call to confirm it because they don't want to make the mistake of arresting someone. So in that situation, unless you can show that the officer knew or should have known that the warrant was no longer a good warrant, then the officer is going to be immune from suit for that violation. And the case law has changed over time, but that's generally speaking the two-prong. One is, did the officer do something wrong? Two, is the wrong something that was well known enough within the police community that the officer either knew that what they were doing or should have known that what they were doing was wrong? And then the question becomes is, when a court looks at it, does the court look at the wrong prong first, or do they look at, is that wrong a known wrong first? Because if you decide that it's not a known wrong, I don't have to decide whether the officer actually did something wrong, actually did it. I just need to decide whether that wrong is clearly established wrong. If it's not a clearly established wrong, we're done, and the officer gets immunity. So that's really what we're talking about here. First case, sort of established that two-prong test for qualified immunity. Did the action violate someone's constitutional rights? If so, was the right clearly established at the time of the misconduct? That was the rule for a long time. In 2009, that rule changed slightly, and it changed in that it used to be that under Saucier versus Katz, that you had to decide the first one first. Did the actions violate someone's constitutional rights? And then after you decided that, then you decided number two, which is, if so, was the right clearly established? Pearson v. Callahan came out and said it's actually within the discretion of the lower court that originally decides qualified immunity as to which prong of the test to address first. And the police were going to want you to address the second one first virtually all the time, right? Because that's really, for, in most instances, going to be where the police win. So they don't want to get into whether or not that messy factual situation of whether an officer actually violated someone's constitutional rights. They want to jumpstart that and decide the second prong first. Pearson v. Callahan says that lower courts have the discretion to do that. All right, so that's the end of the slideshow. And now, as you can now imagine, is that now there's, on top of everything else that the police officer has to think about, they now have to think about, like, is there going to be a lawsuit? And will that lawsuit include me? Will it include my employer? Will it include the agency that employs both my supervisor and myself? Can it include the state if the state agrees to be sued? Will I be sued in state court? Will I be sued in federal court? Who's going to represent me? So these are one of the reasons why this is here is for you to understand that in policing in America, there's a historical aspect to it. There's a modern aspect to it. The modern aspect to it has a lot of rules that the police have to follow. Some of those rules are not particularly clear or easy to apply. There are consequences for failure to abide by those rules. And then overlaying every single thing else is all the different stressors associated with being a police officer. So among the questions that I'm going to ask you to consider is, now at this stage and at chapter 9, again, my question is going to be to you is how hard is it to be a police officer, taking into account all these sorts of things? If we can agree that being a police officer, taking into account all of these aspects of policing in America, what's the next step? What do we do now to relieve stress, to reduce anxiety, to improve performance, to protect constitutional rights of the individual? What's next? What do we do to make all this work? And kind of the broader question is Is all of this resulting in the public being safer? And if the answer is no, then what do we do now to improve public safety? Because I mean, if you ask certain people, they'll say, "Well, you need to leave the police alone. If you leave the police alone, then the community will be safer." Um, so there's always a trade-off, right? If we decide that we're going to reduce or alter the police behavior or what the police can and can't do, oftentimes that has an effect on the ability of the police to keep the community safe. So then you have to ask yourself is what's that break point where we're happy that says this amount of police behavior is good because it keeps the community safe. Anything more than that is more than what we want, and we want to really keep it at this one level. Or do we say this one level is not good enough? We want more police behavior because the community is not safe. So keep those kinds of questions in the back of your head. Otherwise, we'll see you next time. Thanks.